back for another podcast installment of HOA SOS. And Lee today, our Mayday is one of my favorite topics on earth. You get so sick of hearing me talk about it. But it's a fair housing topic that causes a lot of complicated issues in communities that honestly I don't think people always want to talk through. But what am I going to talk about? You definitely know what gets me riled up.
I do. I mean, we are in the dog days of summer, or should I say service dog days of summer. So we are dealing with service animals, assistance animals, emotional support animals.
Yeah, we're going to talk today a little bit about assistance animals. We really hit complicated topics on this program, and I got to say, out of all the things that I've dealt with in a 22-year career, and as you know, I spent a lot of my time before you and I met doing a lot of civil rights work, and honestly, I did both sides of it. I was a plaintiff's employment attorney, and I also defended housing providers, including HOAs, on a number of fair housing cases. But the one thing in the realm of fair housing that really can be a trip up for a community, cause a lot of undue conflict, assistance animals. Let's start there with that term. We hear the term all the time, service dogs, service animals, which, as we know, sometimes could be a pot-bellied pig. We've seen a request for iguanas, boa constrictors. I even had one for a kangaroo. But let's stick with the terms, service dog, assistance animal, companion animal. HUD, our federal agency that oversees the Fair Housing Act, Department of Housing and Urban Development, like to call them DHUD. Their regional director, James Whiteside, doesn't like me calling him that anymore. And he's a friend of mine, lives near me in Arvada. We talk assistance animals all the time. They like the term assistance animals with two species, service dogs or service animals and companion animals or emotional support. That's important because one of the things we run into a lot is two different laws that don't totally have the same coverage. There's the ADA, the Americans With Disabilities Act, and then there's the Fair Housing Act. So from your many years experience as a general counsel, HOA attorney, which federal law really covers HOAs out of those two laws I just mentioned?
Well, we know out of the two laws, it's the Fair Housing Act.
Good job.
Unless you're in front of a kangaroo court. I'm sorry, dad jokes.
Well, we have a few of those out there. They shall remain unnamed. Okay, good. Fair Housing Act. ADA only applies to things that are really open to the public, and rarely would that apply to areas within an association. So stick with the Fair Housing Act. Here's the difference. ADA, only service dogs are allowed, and they have a very narrow definition and do not include emotional support animals. Now, that's important because sometimes I think boards run with that misnomer that they think it's the ADA, and if somebody's got little Chihuahua, let's just call him Angel, Chihuahua named Angel, he's not a service dog, he's an emotional support dog, keep him out. This is a no pet community, or you're trying to bring him into a common area where we don't allow any animals, period. But let's start there. Fair Housing Act allows somebody who has a reasonable need and has a disability and can document that disability, or it's an obvious disability, to have an assistance animal, whether it be A, a service animal, or B, an emotional support animal.
Now, you mentioned kangaroos, you mentioned guinea pigs. Can any of them be a service animal?
Well, you see requests for a lot of wild things, and the answer is potentially. But there's a three-part test. The person has to truly meet the definition of an individual with a disability as defined by the Fair Housing Act, which is somebody with one or more substantial impairments to major life activities, whether physical or mental, okay? Or they have a record of a disability, or they're perceived to have a disability. And then the second big key is they have to need the animal. But you know what? If we're going to dive into that too much, could you get on your cell phone and order some pizza and beer, because this podcast might go for at least an hour and a half.
Yeah. Hey, I would like it, but my diet doesn't allow it.
Oh, you're right. All right. So we better just move on and not dive into that too much.
So now we've actually seen a case recently.
Yes.
That kind of confused the issue between application of an FHA or of
Fair
the
Housing Act.
FHA and the Americans with Disabilities Act in a common interest community, haven't we?
Yeah, it really created, if this was going on in Colorado, one of the more complicated things I've ever seen. And I think one of the reasons, with my civil rights background, that I really provide education on this topic and want to talk about it so much is to dispel the myth that, all right, Wes, I get it. I'm on a board or I'm a community manager. We got to follow fair housing. I get it. But look, at the end of the day, you know, how could somebody really be damaged if they don't get their assistance animal? Where's it really going to expose the association of liability? My attorneys told me that it's very different than employment law, where people could get big verdicts. How are we really going to get clobbered? But therein lies the complexity. So you asked me about a case that we just took a look at that was a lot like others we've seen that dealt with Angel, the Chihuahua. It's a case out of Las Vegas, Sanzaro versus Ardiente HOA. I'm going to give you just a quick down and dirty on this. The plaintiffs, older, moved into a restricted access community. Dog named Angel, Chihuahua. Turned out wildly that Angel is a service dog. It helps the wife pull her walker when the walker gets away. It's got straps. Dog brings it to her, fetches her keys. At any rate, they wanted to use the clubhouse. The wife needs the dog to go to the clubhouse, and this thing really got out of hand. They were asked to leave many times. They were asked for documentation about the disability. Think those of us who have been trained in fair housing know that on the HUD website, and their boss, Department of Justice, HUD, has these joint guidelines that give guidance on how to deal with assistance animals and all accommodations, all reasonable accommodations. And one of the things you can't do, that's a big no-no, is ask for documentation when somebody's disability is what?
It's obvious.
Right.
And
her disability was obvious.
And here, a lot of the case turned on what the association and the manager actually did and how they responded to all of this.
Right, you are, Lee. Instead of knowing it was obvious, they asked her for documentation. Then they outed her in the community, said that they were trying to get around the laws. So eventually it got really ugly, and it led to a lot of the... One thing that worries me about assistance animal issues like this one is exactly what happened in this case. It's one thing to have an accommodation pending where somebody says they need the animal, and there's a debate and a dispute over it, but it can lead to retaliation if boards aren't careful. And that's what happened in this Sanzaro case. It got out that there were legal fees adding up because they're fighting over this accommodation, and there were 3 different incidences where the manager wouldn't let the couple into the pool, the weight room, all the different amenities that are a big draw at this community. And it got out to the neighbors about what the legal fees were, and the homeowners that have the animals start getting threats. And I have to be honest, this is one of these cases that would not happen in 98% of the communities on the planet, or the galaxy if there's HOAs and other solar systems. I mean, this was really radically bizarre. The other homeowners drove these people out of their community, but they filed a lawsuit, federal court, and what happened was wild. 3 things. They had no lawyer, insurance defense company defended the HOA, bench trial, no jury, and guess what the judge did?
What did the judge do?
He awarded these folks $360,000 plus damages for pain and suffering, but then on top of it, Lee, he awarded punitive damages against the board members, the manager, and one declarant that was involved in some of the retaliatory stuff because he felt there was definite evidence of retaliation to the tune of another 300 and some thousand. By the time it was all done, that total judgment for these folks was well over 600,000. So you can kind of see why sometimes I worry about these issues being handled properly.
Let me ask you this. Doesn't the Americans with Disabilities Act really only apply to areas open to the general public?
Yes.
So how did the judge get over that with regard to the use of the clubhouse?
That's a great question, because the plaintiffs did argue that it was the ADA, and he said no. But he got over it because the association, funny enough, had a program where they allowed the public at times to come in. He didn't say that made it an ADA issue, but he said it made it a dwelling unit under the Fair Housing Act because they were allowing people to come in and stay in the model homes next to the clubhouse and the pool and stuff like that to induce people to buy. And because it was such a major amenity and a draw for that community, that for people to not use that, it impacted their dwelling. There was no appeal on that. That was his ruling. And so the bottom line with that is he's just saying that the request for an accommodation to allow the dog into that pool was valid. So at the end of the day, one of the hot topics that we feel with assistance animals is, man, get with your counsel and make sure you're getting really proper advice on how to document it, handle it, and respond appropriately, and keep an open dialogue before you shut somebody down and get the right advice.
But also don't just immediately approve something.
No, that's the wrong way too. Yeah, there's 3 steps to go through, and we educate on those 3 steps, and anybody can reach out to us, and we'll talk about those 3 steps and what an association should do. You get proof of the disability unless it's obvious, figure out if they really need it, they do, and you can grant it, you grant it. If it's reasonable, you grant it. There, reasonable means practical and feasible. Well, that's it for this one. We thank you, as always, for joining us again on a complicated topic that causes disputes, but when handled right, it causes peace or brings peace.
We look forward to seeing you on the next HOA SOS.